Good morning and welcome to today's Advisors Forum presented by Stephen Elville and Elville and Associates. Our topics today are understanding the new 2022 Secure Act regulations and new supported decision-making law and what advisors need to know about them. My name is Jeff Stauffer, Community Relations Director with Elville and Associates, and I'll be moderating today's event. We have many newcomers to our Advisors Forum on today's presentation, so welcome to everyone if you're new to our presentations or are returning to see us again. So you as the attendees are in listen-only mode. However, as always, if and when you have questions, please note them in the questions panel on the right-hand portion of your screen, and we'll take time throughout to address them. Your questions really help the presentation and add value that help others learn, so please don't be shy in posing your questions to Steve and me at any time. You also received some handouts yesterday by email for me to take notes on them if you wish, and if for some reason you did not receive these documents, they are available in the section marked handouts in the panel on your screen to download at this time. And as always, we offer CE for these Advisors Forum and all of our webinars. For CFPs, CPAs, and various other professionals on today's webinar, you may receive 1.5 continuing education hours for attending. And per my attendance records requirements, please email me your ID number. And for CFPs only, I also must have the last 4 digits of your social security number as soon as possible so I can submit your CE hours for approval. Everyone will also receive a post-webinar feedback email right after the presentation. And we do ask that you please just take a couple minutes to fill out this simple survey to offer us your feedback about the presentation. It's also an ideal time to request a consultation with Steve for any planning needs that you may have. And as advisors, we always look forward to getting together with you to learn more about your practice and share a bit about Elville and Associates as well, so we can collaborate together to best serve clients. So here at Elville and Associates, we always look forward to being a resource to you now and in the future. So at this time, I'd like to share a little bit about the firm and Steve, and then we'll get right into the material. So you should be able to see my screen at this time. So Elville and Associates, we were founded in 2010 in Columbia by managing principal and lead attorney Stephen Elville. We do focus on a number of practice areas here at the firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, and tax planning and asset protection. We have 7 attorneys, 12 staff members, and 5 locations. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. We do offer a lot of education here at Elville and Associates, and we do that in many ways. We do that through our planning processes with our clients. We also offer over 100 educational webinars and workshops in the communities that we serve each year, and also by way of our accredited client care program. We are one of only 2 firms in Maryland to have an accredited CCP, as we call it, by the Client Care Academy in Boston. We also work with the ideals of client education, collaboration, and compassion in mind with every client every day. Also, a little bit about Steve, our presenter today. So Steve's work as an attorney the past 20 plus years, 22 to be exact, has been centered in elder law, special needs planning, and estate planning with an emphasis in the areas of tax planning and asset protection. A member of many different national membership organizations, including the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. He works to bring peace of mind to clients by creating solutions to their needs through counseling, client education, and leading edge legal technical knowledge. A very seasoned speaker, if you haven't heard Steve speak, presenting at many webinars, workshops for businesses and their employees, conferences, and continuing education events. Also named to the Maryland Super Lawyers list for a 7th time in 2022 and 6th consecutive year. So congratulations to Steve. Also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, our firm's charitable organization he founded in 2014, and I am privileged to be the executive director of. So if you'd like to learn more about the Elville Center and how we work to make a musical difference in the lives of children each day, please reach out to me or Steve, and we'll be happy to share our story with you. But now is not the time for that. Now is the time to get into our advisors forum. So I'm going to go ahead and turn the reins over to Steve. I'm going to stop sharing my screen and give Steve the presenter rights. Steve, you are going to see that button pop up to give you the controls.
Thank you, Jeff. All right, I'm taking over the screen.
Okay, very good.
I'm going to share my screen and get our slideshow started. Thank you so much, and thank you, Jeff.
Steve, it looks a little small. Is there a way you can increase the size of your screen just a little bit?
All right, let's see. Now, I see a full-size screen here, Jeff. Let's see if I can do it again.
There we go.
How about that?
That looks good.
All right, thank you so much. Well, good morning, everyone, and happy Wednesday to you. I am coming to you from our Annapolis studio here in the center of Annapolis, and it is, to my knowledge, it is graduation day for the Naval Academy. I was here yesterday doing some work, and the Blue Angels flew over several times, and now they seem to be pretty quiet this morning, but if it happens and all of a sudden you can't hear me, you'll know what's happening. So hopefully the Blue Angels are not going to fly or practice until this afternoon, but if they do, you'll know what's happening. So wherever you are, your time is extremely valuable, and it's my privilege to be with you this morning and share some information and get into some of the basic details of the Secure Act proposed regulations and supported decision making, which I'm very excited about. I know many of you are friends of Elvil and Associates. We just had our client event on Saturday. I want to thank Jeff for not only helping me put on these kinds of webinars, but also for the stellar job he did for our client event. And some of you were able to attend. And if you weren't able to attend, you're welcome to come next year. So thank you again for spending your time with us this morning. All right, so I am going to get right into the information, and we have a lot to share. I want to make sure that you walk away with something that's very substantive from this today. I want to make sure that you have a scope of an idea, not just some facts and bullet points, but I want to really impart some things to you especially as we get into the Secure Act proposed regulations. So most of you are very familiar with what's happened since President Trump signed the Secure Act at the end of 2019. It became law in January of 2020. And many of you are cognizant of the basics surrounding the Secure Act, but the new regulations, the proposed temporary new regulations, came out this spring. And even the best minds in the law, and I know the best minds in accounting and the best minds in financial advisory world, are trying to sort out these regulations. So we're not going to solve all of the problems today. We're not going to be able to get to a lot of answers. But I hope that what I can do today is set a framework of how I think we should approach the Secure Act regulations. Because, for example, this morning, I was just in touch with someone, and I had been working on their documents for the last 2 or 3 or 4 days. And this person wants certain provisions relating to their retirement plan assets and how they should flow in relation to other assets. And I had to draft the trust the best way I could, because we are dealing with proposed temporary regulations and not something that's really 100% solid, not 100% permanent. So I had to draft in a way that says, well, here are what the Secure Act regulations are now, the proposed temporary regulations, but I had to leave room open for the possibility of change. So if all we do today with the Secure Act portion of this presentation is walk away with an idea that we have to remain flexible, we have to take every set of facts and look at it from top to bottom, and we have to work together as an advisory team, the lawyer, the financial advisor, the CPA. We have to do this well, or we will not have a good result. Now, generally, we would say that same thing about any situation relating to client relations and client care. We want to have a collaborative approach with financial advisory persons and lawyers and CPAs. We want to have that collaborative approach in any event, but with the Secure Act, we definitely want to make sure that we are cognizant from the time the client does their planning, does their beneficiary designations, funds their planning. We want to make sure that we are all on the same page, because if we are not, I'm going to give you some illustrations of what's happening, and many of you are aware of what's happening after someone dies, that things are in kind of a disarray. So we don't want that to happen. So we're going to talk about the basics today of the Secure Act. And then I'm going to bring you into the world of supported decision making, which we've talked about before, but now that law has passed. It has passed in Maryland. It is going to be effective October 1st, 2022. So this is quite a departure from the Secure Act. This is a different subject altogether, but I'm going to bring you into the world of why this is so important for you to understand this paradigm shift in the law with regard to people who are disabled. And what is the purpose and what is the promise of supported decision making in Maryland? And what does this mean now in relations to powers of attorney and advanced directives and guardianship? And these are things that's going to touch on you, or you're going to have touched it in your practice and with your clients, and you're going to need to know how it works. You're going to need to know how to deal with people who are going to come to you now and they have a new set of rights under the law. It's actually the same old rights as they had before, but a new way of recognition of those rights, and you're going to need to be aware of this. And in many ways, this is very simple, but it's earth-shattering, and I want to make sure that you get the full scope of it. So we're going to review all that legislation and get into it. So let's get started, and I know that was a fairly long preamble to the discussion, but I'm trying to set the stage adequately. So as I just mentioned, the Secure Act came into effect in January of 2020, and now we have, again, more proposed but not final regulations. And let's just get into some of the basics. Many of you know these things already, but what you're going to see now are there are some changes. If you haven't been cognizant of this yet, if you haven't reviewed this yet, some of this basic information is going to be very important for you. If you have not purchased this book, Life and Death Planning for Retirement Benefits, I believe that's the name of it, Life and Death Planning for Retirement Benefits by Natalie Choate, who in our world is the leading authority on planning for retirement plan benefits. I strongly recommend you buy that book, but you should also be aware that even Natalie and many of the experts are struggling to really get their arms around these new regulations. So if you buy it, you may have to buy the revised copy soon, but you need to be aware that that kind of material is out there. So the stretch IRA is eliminated, as you probably know, for most people since January of 2020. So we know that for most people, we will not be able to stretch out or defer taxation on IRAs for regular purposes anymore. We just won't be able to do that for the vast majority of people. There are 5 categories of eligible designated beneficiaries. So let me stop right there for those of you who are not 100% on top of this information. We used to have 2 types of beneficiaries. We used to have a non-designated beneficiary and a designated beneficiary. And a designated beneficiary was someone who could stretch out IRA assets indefinitely over their life expectancy if they did not use the money. Well, now we have 3 categories. We have the designated beneficiary, we have the non-designated beneficiary, but we also have a new category, eligible designated beneficiaries. These people are exempt under the Secure Act. And so let's talk about those 5 types of persons. Surviving spouses are exempt. Minor children are exempt. People with chronic illnesses are exempt. People with disabilities, as defined by the IRS code, are exempt. And people who are less than 10 years younger than the plan participant are exempt. So many of you know that. I'm just reemphasizing these people who are eligible designated beneficiaries. They are still exempt. So that didn't change under the new proposed regulations. but the acceleration of income tax is still a huge problem. And every month that goes by, I see clients that are more and more concerned about this. And I know you're seeing that in your practice, as most of your clients are accumulating very large retirement plan assets. I strongly recommend the collaborative approach to look at life insurance and other types of mitigating tools to try to deal with this huge problem. So I think that the more we get into the weeds with clients on this, the more they're going to be concerned, and they're going to want to do wealth transfer. But again, I know many of you are already doing that. I want to encourage us to work together to do that. Now, the IRS did make some very positive clarifications. The required minimum distribution rules are clarified more. They are improved more, okay? See-through trust testing is simplified. Now, for those of you who don't know what I'm talking about the use of let's say, a revocable living trust. And remember that if that trust meets the requirements of the IRS code, and if a retirement plan asset is left into that trust, if it is beneficiary designated to that trust, the IRS will allow that trust to be a see-through trust, meaning the IRA asset will go straight through that trust as if it doesn't exist. But that has been simplified because it used to be very complicated. So that's a good thing. That's a positive thing. The age of majority has been clarified. So for example, we know that minor children are exempt, but in many states, minor children are minors until the age of majority, which is 18. But now IRS has clarified that and said the age of majority is 21. So a minor child who is exempt from the Secure Act, and that means that they can take a life expectancy payout after the death of the plan participant, if that were to happen. That child now is exempt until age 21, and they basically have 10 years to take the assets out. So that has been clarified, and that was one of the things that was hanging around, and we didn't know what the answer was. And there are many other clarifications for complex estate planning, and we're not going to be able to get into all of those things today, but I just want you to know those things are out there. And for every slide that I go through today, I'm going to try to emphasize that the more planning that's done up front, the more understanding of what the rules are going to be as far as how they're going to affect the retirement plan beneficiary designation of assets to a trust or not to a trust, and how that's going to be treated. The more understanding up front, and I think the more discussion up front about that, the better the results are going to be at the end, because I think a lot of things right now are very much all over the place after someone dies. Now, we have, again, the good news that things have been clarified, but we still have the bad news that the 10-year rule applies. Now, remember, that applies to designated beneficiaries. As Natalie Choate would say, the plain old designated beneficiary. The person who is probably the 98% of people who are not exempt from the Secure Act. If there's a proper beneficiary designation, they are going to have 10 years. So if death occurs before the required beginning date, and what's that? Age 72. Someone dies before the required beginning date of required minimum distributions, 100% of the balance of the IRA has to be distributed by the end of year 10. So I'm dragging you into the weeds here. Many of you already deal with this every day, but I just want to emphasize again, the more that we can focus on this up front, the client does estate planning, the client does good estate planning, and they actually fund their estate plan, and we're working collaboratively from attorney to financial advisor to CPA. The more the results, the after death results of these beneficiary designations and this planning, the more that's discussed, the easier things are going to be on the back end. Now look at this 10-year rule as it relates to death after the required beginning date. Now these are a little bit of the changes that are occurring. So we have death before the required beginning date. That's pretty straightforward. If someone is a designated beneficiary, they have 10 years. If someone is an eligible designated beneficiary, they have life expectancy treatment, basically, although there's a lot of nuances. But if someone is a non-designated beneficiary, they only have 5 years. So I'm calling it the 10-year rule, but that's for designated beneficiaries. There could be a 5-year distribution, very bad. But look at the second bullet point here. What if death occurs after the required beginning date? Well, there's something called the as long as required application, at least as rapidly. So here we have a situation where an old IRS rule was not repealed by the Secure Act. So even though we think that annual distributions are supposed to be on the life expectancy of the deceased, because that person was beyond their required beginning date, or 10 years, we have this as at least as rapidly rule. So this is very interesting to look at, and this goes to show the nuances that we're dealing with. Look at this sentence I have here. Annual distributions are paid to the designated beneficiary for their life expectancy, over the first 9 years. And then in year 10, 100% of the IRA must be distributed. So the problem we have here is that we are actually having two rules as it applies to the 10 years. Now, of course, it could be faster than this. I have a client right now who understands this rule, but the client wants to make sure that even though she's past the required beginning date, she wants to make sure that the beneficiaries receive all of their retirement assets within 10 years. So she wants a 10-year payout no matter what. What this is saying is that if you did not have a equal distribution over 10 years, the at least as rapidly rule applies. And the designated beneficiary would be able to take minimum distributions based on their life expectancy for the first 9 years, and then not have to take the balance until year 10. So these are the kinds of nuances we are dealing with. And I think that we should take nothing for granted as we continue to get into the meat of the discussion here. Now, one of the major things, as Natalie Choate sets out as she tries to explain the new rules to the legal community, who basically look to her for guidance, we have two structures with these new Secure Act regulations. So we have the annual distribution track. We have to think in terms of what is the requirement of annual distributions after the person's death. So the first thing we should be thinking about is who is the person and what are their annual distribution requirements after their death. We have to ask ourselves, who is the beneficiary? Okay. Now remember that there are no annual distributions required under the 5 and 10-year rule. Okay. So if we have a non-designated beneficiary that and the person died before their annual or their required beginning date, we have no annual distributions. And if we have no annual distribution requirement other than the one we just talked about, we have none under the designated beneficiary rule. So the 5-year rule, non-designated beneficiary, 10-year rule, designated beneficiary, no required annual distributions. Okay. Annual distributions for the life expectancy of a non-spouse beneficiary. Well, we just talked about a little bit of nuance on that. Okay. What if that person is an eligible designated beneficiary, like a minor? Then there would be annual distributions required. Okay. What if the person met the requirements of one of the other eligible designated beneficiary categories? There would be a life expectancy payout. What if the beneficiary of an IRA was a qualifying trust, like a special needs trust for a chronically ill person or disabled person? Then the life expectancy payout would also occur. Okay, so we have all of these nuances. We have to ask ourselves who the beneficiary is, and are they a designated beneficiary, a non-designated beneficiary? Are they a non-spouse? Are they an eligible designated beneficiary? Surviving spouse life expectancy payout, okay? So the surviving spouse life expectancy payout, this is going to be a fact that are related to the fact that the surviving spouse is an eligible designated beneficiary, okay? So we have to, again, be aware of who the beneficiary is, okay? If the person is beyond their required beginning date, then we have the longer of rule. And is it on the longer of the beneficiary's life expectancy or the decedent's life expectancy? Okay. And of course, the ghost life expectancy of the decedent. All of these little nuances are beyond the scope of today's discussion because there are literally thousands of examples. But where I'm going with this in each slide that I do is I'm reemphasizing again that we have clients, they are of a certain age, and of course they should keep their planning updated, and they should revisit their beneficiary designations. They should revisit their trust planning. They should revisit all of this planning. And when they do, we need to look at the existing regulations, whether they are the temporary regulations that we have now or the regulations we will have in the future that will probably be permanent. We need to look at those regulations and say, not only what do we want to do right now on the front end, but on the back end, what is going to happen when the beneficiaries actually take these assets, and how mechanically will that work for them so that everyone has an understanding of what the result is of this. All right. So where our first track is the annual distribution track. We ask ourselves who the beneficiaries are. Are they eligible? Are they designated? Are they non-designated? What is the rule? What is the regulation as it applies to them? Then we have to look at the outer limit. We have to say to ourselves, notwithstanding who the beneficiaries are and how their distributions are going to be paid annually or not, we have to look at when all of the assets have to be distributed. So we call this the outer year limit, if you want to look at it that way. So two major things, the annual distribution track and the outer limit track. So again, we look at who the beneficiary is. If it's a designated beneficiary, the funds have to be out of the IRA by the 10th year. If it's a minor beneficiary, we have 10 years from the anniversary of the 21st birthday or death, whichever one occurs first. And then of course we have eligible designated beneficiaries other than minors. And those, remember, are spouses, chronically ill, disabled, or persons who are less than 10 years younger. Those are the life expectancy payouts for those people, or the 10th anniversary of death, okay? So that's what we have to consider as we look at these two structures. Now, as we talk about leaving assets to surviving spouses and others, we have to realize that because surviving spouses are exempt, rollovers, meaning the outright distribution to spouses, they still remain the most efficient things. But of course, we know lots of things can happen there in planning between spouses. There might be a need to control assets or to use a marital trust and make sure that assets are controlled down to beneficiaries, okay? Inherited IRAs, okay? Distributions, when are they going to start, okay? So if a surviving spouse who is an eligible designated beneficiary, if he or she takes an inherited IRA, then of course we don't have that life expectancy payout, okay? So we have to consider when the distributions actually start. And if we are leaving assets to surviving spouses in a trust, we have to decide, are we going to use a conduit trust, which is the simplest way of doing it? And sometimes we use a Q-tip trust to control the assets, and it also has to be a conduit. So it has to meet the requirements of both, and that's going to be a double-edged sword. So if we use a conduit trust, we're going to have the best tax treatment of the IRA assets going into a trust, but we're also going to have the least asset protection, which is one of the reasons for using the Q-tip trust. So we have to juxtapose the tax problems with the asset protection problems, okay? The accumulation trust for a surviving spouse, that gives a great asset protection for the deceased spouse, knowing that they're protecting assets from a new marriage or going and making sure those assets go down to children and grandchildren. But there's going to be a tax cost of using that accumulation trust. Now, there's been a simplified rule for identifying beneficiaries, and I'm covering as much as I can this morning just to try to give you a feel of the complexity of these rules and why we have to think through them in each stage of the client's life, okay? Remember that if a IRA is left to a trust, we have to ask ourselves, does the trust qualify as a see-through trust? It has to be valid under state law. It has to be irrevocable at death. A copy of the trust has to be provided to the plan administrator by October 31st of the year following death, and the beneficiaries must be identifiable. Well, those rules have been simplified, okay? And we have to ask ourselves, is there a designated or eligible designated beneficiary? We have to ask ourselves those questions at all times. So if you're with me so far, that we have a revocable living trust, and that has been beneficiary designated, an IRA has been beneficiary designated into that trust, okay? We used to have a lot of problems with this, because if someone wanted to leave assets where they were very strictly controlled, or if someone wanted to leave assets through a trust like a retirement plan, that retirement plan could implode as it's going through the trust. Either the trust did not qualify as a see-through trust because of some problem, like a charitable beneficiary being in the trust, and that would have to be dealt with, or we simply were holding assets in trust for many generations. And Uncle Sam does not like this in the old rules, because Uncle Sam wants to know, when is the tax going to be paid? Basically, Uncle Sam wants to know, when will someone receive these retirement plan benefits outright so that Uncle Sam can tax them? Well, that has been simplified now. So instead of there being, for the best way I can describe it, kind of an unlimited depth of analysis that we would have to jump through hoops to try to figure out how to avoid the IRA assets not receiving favorable treatment. Now, the in-depth testing has been eliminated, and there is a simplified testing. So if we are leaving assets to a trust, the analysis is in really 3 tiers, and we can disregard the 3rd tier and really look to the first 2 tiers. And if we look to those first 2 tiers of beneficiaries, the persons who could inherit the plan, we will find that most of our problems that we used to deal with about having an IRA going into a trust and the possibility of the IRA really imploding and all of the tax being due within 5 years, most of those problems have now been eliminated. And I will not drag you through all of these things here on this slide, but again, I want to emphasize that we have to decide among ourselves as the collaborative team, and I ask for your help on this, to please help us as we're doing planning up front to understand what is going to happen on the back end. The client has a certain family situation. The client makes their beneficiary designations either outright or, in this example, in trust, okay? But now, when the client dies and death claims have to be made and inherited IRAs have to be set up, let's say for non-spouse beneficiaries, or even for a spouse beneficiary who is going to have assets in a marital trust or a QTIP trust, we as the collaborative team need, especially at that time, to work together. Because what I am finding in our practice is that in the post-mortem period after someone's death, I am finding that the financial advisory firms that we are dealing with, or the back-end offices of your firms, we're having a real difficult time. Some of it is because of COVID and some of the things that are going on in the back offices of many broker dealers or financial houses, where employees are working from home and there's a lot of confusion. But some of it is just a plain lack of education on the part of some of the back office staff. Now, this is not true of every firm, but what's happening is some of the clients are suffering because they have left assets in a certain way to go to trusts for beneficiaries. And to accomplish what we need to accomplish, we need to establish inherited IRAs that are owned by those trusts, and that is going to satisfy the deceased person's intentions to provide asset protection for that IRA to go into trust. So we want to ask for your help to understand that this is a big educational piece right now that I am seeing a lot of problems with the back offices of financial advisory firms not really accepting responsibility for helping the surviving person, the surviving beneficiary, get from point A to point B. And that's a big change, a lot of change, of course, in the world since COVID-19. But that is my focus here, is to try to say there's some simplified rules, there's a lot of positive things here, but there's also a lot of confusion. And we really need to commit to work together, especially after someone passes away, to make the connections that have to be made to get inherited IRAs situated in continuing trusts. Now, the other issue, as we start to wrap up this portion of the presentation, another issue that we're dealing with is basically just the issue of where the beneficiary designations are made. So for example, on the planning end, many times we are, or most of the time, we are planning with clients, we are making designations of beneficiaries and recommendations of beneficiary designations. So important because of the size of the assets these days that are in retirement plans. So we make those recommendations, we're working with the financial advisory team, but then we find that at someone's death, those instructions have either been ignored or they've been misinterpreted. So don't have time to go into all of this today, but one of the things to take away from the complexity of the Secure Act and what it means for clients who are trying to make the most of their retirement plans and also provide protection many times in trusts is sometimes we will beneficiary designate assets to a spendthrift trust for a beneficiary that is created under a revocable trust or a will. So we might call that a subtrust. But when we actually get to the time of death and we actually find out what the beneficiary designations were through the financial advisory company, we find that the subtrust itself was not beneficiary designated as the beneficiary, but that the revocable trust itself was the beneficiary. And that gets us back to this slide about the see-through trust. There is a difference between beneficiary designating an asset to a revocable trust, which clearly needs to qualify as a see-through trust, and beneficiary designating an asset to a standalone trust or a standalone trust different from the revocable trust or a subtrust. So this is something where I think that between the advisors on the collaborative team, somehow, and that includes attorneys, somehow the ball is being dropped many times with the nuances. Is it to be designated to the revocable trust or designated to a subtrust, which Natalie Choate recommends many times is the much more efficient way of dealing with things. So when we have surprises about where the beneficiary designations actually end up being, that creates a further complication. So again, I'm repeating myself here, unfortunately, but intentionally, that the more we can work together up front, the more clarity we can have, not only with the client, but with the advisory team as a whole, and the more clarity we can have about what the end results are and the net outcome of what these beneficiary designations are going to mean and how they actually get established, and the commitment on all of our part to get those things done in the months and weeks following someone's death, the more results we're going to obtain, and we're going to get away from some of the negative results that I'm seeing right now because of a lack of understanding, lack of education, or lack of cooperation between the advisory teams and the back offices of many of the IRA custodians. So thank you for listening to me go on about that. I thought it was important to bring that out, okay? Again, eligible designated beneficiaries as far as disabled or chronically ill beneficiaries have been further clarified. Okay, so the IRS basically says, and the regulations basically say, an individual who is 18 or older who cannot engage in substantial gainful employment. That's a very big buzzword, substantial gainful employment. A person who is not 18 or older but has a marked or severe medically determinable impairment, physical or mental, or someone who is deemed by Social Security to be disabled for SSDI, for example, Social Security disability. So this clarifies a lot about people who are disabled and whether they actually meet the definition of disability. Many of those things have been clarified in the Secure Act, new regulations. Other things to be aware of beyond today's presentation are, again, I mentioned this early on, regulations affecting complex situations. Now, what we already talked about seems complex, but even more complex situations, like the treatment of multi-beneficiary trusts. So how the oldest beneficiary's age is defined for purposes of the minimum distributions, if those minimum distributions are required, because all of the multi-beneficiaries are eligible designated beneficiaries. Trust toggling, whether a trust can be toggled to be a designated or a non-designated beneficiary, or more exactly to say whether it can be a grantor or non-grantor trust. Beneficiaries qualifying for eligible designated beneficiary status in more than one way. There are circumstances where someone could be an eligible designated beneficiary more than just in one category. Powers of appointment, how does the IRS treat those? Decanting, how does the IRS treat those in the new regulations, and reformations? So it's quite complex, and I'm hoping over the last 30 minutes or so that I've been able to share some of my concerns, but also let you know that some of these things, although they remain the same in many ways, they've been nuanced and adjusted in many ways, and the problems that are being created, not only because of the logistical issues with COVID and the changes in the world, but also how these regulations are going to continue to impact how people are planning for their large retirement assets and what the ultimate outcome is going to be. The more we can stay on top of this up front, the better. And I invite you to do that and collaborate with us, and we would collaborate with you on the front end of planning during the lifetime of the client and on the back end. Now, with that said, that's a lot to throw at you this morning. I appreciate your indulgence on that. Now I'm going to completely switch gears, and I'm going to get away from technical things, and I'm going to get away from the IRS and the world of trusts and estates, and I'm going to get into more now the world of disabilities. And I'm going to talk about supported decision making and what it is and what is its promise. So as a very brief background, I have been involved in the elder law community for many years, and do a lot of special needs planning. And as a result of that, we see a lot of persons with disabilities who need guardianships. And about 10 years ago or so, I was at a presentation at the ARC of Frederick in Frederick, Maryland, and I met someone named Megan Rusiano, who is the big proponent and the person who drove this legislation in Maryland. She is the proponent of supported decision making in Maryland, along with several others. And I presented on guardianship. Megan presented on supported decision making as an alternative to guardianship. And that really started my education in something that I've become quite passionate about, but it led through many ups and downs. And this was really Megan was the driving force of this through the Elder Law Section Council and the Elder Law Section in the Maryland State Bar Association, and many other proponents across the country. And we were able, Megan was able, I should say, with the help of some other people, to push this legislation over the goal line, and it's going to make a huge difference for people now. It will be effective October 1st, 2020. So supported decision making is a tool. It is a tool where a person with disabilities can be empowered and supported. So in other words, The idea is actually very simple, and many people are going to make this more complicated than it really is, but the idea is very simple. People with disabilities, they are going to be able to make their own decisions in many cases, in most cases, and if they have enough support to do so, they can make a lot of decisions. So the real question leading up until this legislative session was, is the state of Maryland willing, collectively, the citizens of Maryland, to provide people with disabilities with enough support so that they can make their own decisions to whatever extent they can? That was really the question. So this is a paradigm shift. Here's an example. People with disabilities need protection. People with disabilities, if there's any question about their capacity, they need to be under a guardianship. Well, what do we know about guardianship? That takes away their legal rights. So this is a shift from an idea of protection of people with disabilities to the idea of allowing, so to speak, people with disabilities to take risks, to be able to make their own decisions to whatever extent possible. So this can be a simple written agreement, and even though we don't have those agreements yet in Maryland, Jeff has given us some samples here at the end of the presentation of simple supported decision-making agreements in places such as the District of Columbia, Delaware, and of course there are several other states now, but prior to Maryland having supported decision-making, we were kind of behind the curve, which is not surprising in many ways. Alaska, Indiana, Wisconsin, Texas, all of these states were more progressive than Maryland with supported decision-making. So it can be a written agreement, but you need to know that it can be a verbal agreement. It does not have to be in writing. And this is something that's going to become an epiphany as we continue to go through this. So this law formalizes the ability of someone to have a supporter. It's an alternative to guardianship. You'll find in this presentation that a person under guardianship can have a supported decision maker. So not only can they have one outside of a guardianship, but even if they are already under guardianship, they can have a supporter. This is in addition to a financial power of attorney or advance directive. Let's talk about this for just a second. We're going to talk about this in a little bit more depth, but if a person has financial power of attorney and advance medical directive, that means that they have the mental capacity to understand and appreciate the nature of that document. Now, just because they have that, that means that the person has a person who can step in for them, who can take care of them and pay their bills and make their medical decisions if they cannot do it themselves. But this is different. The same person with disabilities can make appoint a supporter, a supported decision maker, and that supported decision maker can be in addition to this person's power of attorney and advanced medical directives naming agents. So those agents act for the person if they can't do it themselves. The supporter helps the person make their own decisions. So as you're going to see today, the supporter does not have any decision-making authority, okay? So it's a very powerful tool. It is part of a paradigm shift, and there's a whole new world of self-determination for people with disabilities, whether they are young or old, whether it's a person with a cognitive disability or whether it's a person who's just aged and they have other types of diminished capacity or disabilities. So as I mentioned, Megan Rusiano was a key player in this legislation. I was privileged to be able to give some testimony to the Maryland General Assembly and help Megan, but Megan really was the main proponent of this, and this is long, long overdue and a very, very big change that is going to take some time for us to get our minds around this. And as I mentioned, it was in several other states before Maryland. Maryland finally has joined its neighbors, Delaware and the District of Columbia. Megan, for example, came from British Columbia, where supported decision-making is very prolific. It is something that is mandated by the United Nations. So the United Nations Declaration says that this is something that needed to happen so that people with disabilities can actually be free and be treated as persons who can take risks on their own. but this is very difficult for people to get their minds around, including lawyers and legislators. People had a lot of fear of change and a lot of fear of fraud and abuse. Now, those fears are going to continue, but hopefully we will continue to work through the issues and allow people with disabilities to take risks and make decisions to whatever extent that they can. Now, this was needed in Maryland so much because there was no good alternative to guardianship. We either had someone who had the mental capacity to be able to sign or appreciate powers of attorney or advance directives, or we didn't. And if they couldn't, and if that person's capacity was borderline, they could find themselves in a guardianship where they lose their legal rights. So there was no formalized way for people to be supported. It just did not exist in the law. There's no annual review of private guardianships. So let's say someone was under a guardianship. Well, that could be forever because the court does not have any mandate to have to review that every year, whereas they have to review public guardianships, okay? There was no clear way for alternatives to guardianship to be explored. So alternatives to guardianship are definitely supposed to be explored, but they weren't really being explored in all courts. So the judiciary was very inconsistent. A person really that is being the subject of a guardianship has the right to come to court, to be heard, but that did not always happen. And there were lots of old notions of traditional guardianship that finally appear to be no longer needed. And my last bullet point here of paternalism. So the idea of taking care of people with disabilities instead of allowing them to take some risks has really hurt people with disabilities. And again, I'm going to be the first to admit that this is not going to be something that's going to be easily implemented, I don't think. I think there's a possibility it could be pigeonholed and not fully utilized. I think there are risks, but I think that the risks are outweighed by the rewards. And I think that's the general consensus of many people. Now, again, what were those tools that were available prior to supported decision making? Well, financial agents under a power of attorney, healthcare agents under a medical directive, those were alternatives to guardianship, and they still are. Those are the reasons, those things are the reasons why we don't have any guardianship, because we have an agent under those documents and we don't need a guardianship. Other lesser restrictive alternatives to guardianship have always included representative payees for Social Security, joint ownership of financial assets, surrogate decision making. Many of you may or may not be aware, if I go to the hospital and I did not have an advanced medical directive, I still do not need a guardianship of my person because I probably have a surrogate decision maker. I'm married, my wife is my surrogate. If she can't act for me, my daughter could act for me. Under the law in Maryland, there is surrogate decision making. Now, we still want to have an advanced medical directive because we don't want to risk guardianship. So there's guardianship of the property. I don't have an agent under a financial power of attorney. Guardianship of the person. I don't have an agent and I don't have a surrogate decision maker. So those are going to strip me of my rights to my property, the rights to my person. But with supported decision making now, there'll be a great alternative to minimize the number of guardianships or even eliminate guardianships that are in place right now. Now, prior to supported decision making, a lot of attorneys in guardianship were doing what they call settlement agreements. They were creating their own agreements because there was no in-between between agency under powers of attorney or advanced directive and guardianship. There just were no good middle of the road alternatives. So now for many of you and your clients, you're going to be able to advise them or tell them that this exists, that supported decision making actually exists, that their loved one, whether they're young or old, they can appoint a supported decision maker and avoid guardianship in many cases, or supplement guardianship in many cases, and in addition to financial powers of attorney and advanced directives, be able to have support that's more formalized to do whatever they can do themselves with the support that they need. So supported decision-making is not a financial power of attorney. We're talking about this in various ways just to drive this point home. It is not a financial power of attorney. It is not a way for a supporter or the third person, the third party, to make decisions. That supporter has no decision-making authority, okay? It is not giving authority to that person to do whatever they think is best. That is one of the things that's strictly prohibited. It is not a mechanism by which the person with disabilities gives up their rights. So the person who appoints a supporter is not giving up their rights. And it is not, as I've mentioned, it is not adult guardianship. So I think it's very important to understand what it is not, okay? And what are the differences between supported decision-making and guardianship? Now, for those of you who are doing a really good job here of trying to keep up with me, taking in all this information, making some notes, I hope, I want you to be thinking, if you're not already thinking, how is this going to affect me? I've got someone coming in to see me. They could be young, they could be old, they could be middle-aged and have children that have disabilities. They come in now and they're opening up accounts, or they are negotiating or dealing with their accounts. They are choosing a financial advisor. They are making decisions about their financial planning. And this person is clearly disabled. This person is clearly someone that in the past you might have had some trepidation about dealing with them, or asking whether this person has the ability to actually be making any of these decisions. Are they competent? Well, now you need to be aware that the formalization of this relationship, which we're going to talk about in the legislation coming up here, this is something that you're going to need to handle correctly, and you're going to need to learn what we're talking about here in more depth. All right, now back to the subject matter here of the slide. Supported decision-making is not guardianship, because guardianship is about the removal of rights, okay? The removal of the rights of a person to where they live and to their property and to their health care, even taking away, in many cases, the right to vote. They have no legal choice. And this is a result of the paradigm of protectionism, I like to call it. No right to take risks. And society's fear that if these people fail, that very, very bad things are going to happen. So again, I'm not saying that this is completely free of risk, but this is the difference between supported decision-making and guardianship. No review of guardianships that are private, okay? And many, many people will ask, well, is this permanent? And the answer is no, it's not supposed to be permanent, but the reality is that it is permanent for most people. So that is not supported decision-making. Supported decision-making has no removal of rights. There is no removal of the rights of the person. They don't give up anything. And a person, and there are already many cases happening like this, where someone is under guardianship, but now with the ability to appoint a supported decision maker and a review of the guardianship, because remember, private guardianships are not reviewed every year. Now the guardianship can be removed and the person's rights restored. With supported decision making, the person's right remains vested. Their rights remain vested in them, the rights of their person and the rights to their property. They have a right to fail. Again, not free of risk, not something I'm taking lightly, not something you should take lightly, but we need to recognize they, meaning persons with disabilities, cannot achieve their potential without the possibility of failure. It can be part of guardianship. So now this is a tool. This is a tool for a judge to be able to say, hey, I've got a guardianship here. I'm not 100% convinced this person can't make any of their own decisions, but I do believe they need protection, but I'm going to allow that person to be able to do certain things that prior to supported decision making would have to be negotiated in a consent order, in an agreement before the court. But now this person can appoint a supported decision maker and have more right of self-determination even under a guardianship. Again, as I've mentioned a couple of times, it's in addition to a financial power of attorney or advance directive for a person who does have those, but also wants to have a supported decision maker. What if the person has no financial power of attorney or advance directive? They still can appoint a supported decision maker. Now, a financial power of attorney and advance directive, we know that the agent acts on behalf of the principal according to the powers given to that agent. The document says when the power becomes effective, it says the agent is to act for the principal when they could not act for themselves, okay? The financial responsibility of accountability is on the fiduciary, the agent, and it can be terminated by the principal at any time. It is a substitute for guardianship, as we've discussed. But with supported decision-making, back to the converse here, there is no agency relationship. There is no agency relationship like a power of attorney. The power of the principal remains vested in them. The principal, the person with disabilities, makes their own decisions with the help of the supported decision maker. This is very important. No authority for the supported decision maker to act for the person. We've talked about this a little bit. The accountability of the supporter is going to depend on the jurisdiction. And for those of you who are starting to get the picture here of what I'm talking about, the epiphany of what you're going to start to feel from this is that this is a whole new ballgame. Where does your liability begin and end? What are your responsibilities of dealing with the supporter and the person who has the supporter with them? The supporter's decision-making role can be changed or terminated. So I should have said that differently. The supporting decision maker's role, not the supported decision-making authority, but their role can be changed or terminated, and this is seen as a substitute for guardianship. So far, we've got about another 20 or so minutes to go. So far, we've gone over the basics of the proposed Secure Act regulations, tried to get through some of those as quickly as we could. I've tried to cover the new supported decision-making idea in Maryland, the new legislation that's effective October 1st. Now we're going to drill down into the legislation in the interest of time. Now, this legislation is something that I would highly recommend that you review. Jeff can send you these particular slides and make sure that you have them as a tool. But here's what I would highly recommend, and most of us would not want to sit around and read legislation. This legislation is not complicated. And I think if you will take the time to sit and read it, you will have this epiphany, this new awareness that will just be, I think, quite surprising to you. So let's go through this in the interest of time. I want you to just take this in and let it sink in. Supported decision-making can happen in Maryland with or without a written agreement. Think about that. Without an agreement. The supporter is there. There's no agreement except a verbal agreement. And it does not have to be just one person. It is a series of relationships. It could be 5 persons who are empowered by the principal, by the disabled person, to do what? To make, communicate, or effectuate the adult's own life decisions, to help him or her, okay? So as we go down here, I'm just trying to make certain things clear. Remember, the supporting arrangement can be plural with more than one person. And this issue is how the adult uses the supporters to make their own decisions. Everything is surrounding the rights of the adult. Everything is surrounding the responsibilities of the supporter. Now, a supporter is an individual selected by the adult or individuals, plural, to provide support. And here's the key: to provide support in making, communicating, or effectuating the adult's own life decisions. Notice that nowhere here is the supporter making any decisions, and they have to refrain from that. I will tell you a very brief story. I was very lucky in my life, very fortunate, to know someone named Lois, who was a very elderly disabled adult who had been cognitively disabled her entire adult life, but she was not under a guardianship, and she had signed an advance directive and power of attorney many years ago before I met her. Well, she's recently deceased, but she was an amazing person. But even possibly more amazing was the support that she received from the supporting organization. in Greenbelt and Beltsville area. And every time over a period of years that I visited or that I saw her in her environment, I was always amazed. And I'll go ahead and give kudos to someone named Audra Mitchell, who was Lois's supporter. And it is true that there was no supported decision making back then. And it is true that Audra was a paid caregiver or provider or supervisor for Lois, but I was always amazed that in her role as the supporter, she was always deferential, always playing the role of the true supporter in helping Lois make her own and communicating her own decisions about her own life, her own preferences. And as a result, Lois had a very high level of life, even though the special needs trust that her mother left for her was not extremely large. She was able to take vacations and enjoy a very self-directed life because of someone like Audra. That's why I'm so excited about this legislation. But for you and our purposes here today, we need to start the long process. It's going to take a long time to learn how to deal with people who are now empowered that we once did not think of as empowered to make their own decisions. The supporter and the purpose of the legislation is to be able to help in making and communicating and effectuating decisions that are the preferences and choices of the adult, to prevent, and I thought this was amazing, to prevent the appointment of a substitute decision maker for the adult, including a guardian. So think about that. The legislation is to prevent this, whereas our entire adult lives, we've been taught to protect and we've been taught to appoint substitute decision makers. This is saying the exact opposite. An adult may use supported decision making to increase their own self-determination, prevent the need for a substitute decision maker, or limit or terminate the use of a substitute decision maker. This is what I was referring to as what's happening in the world of guardianship. That guardianships in the future now, if you are dealing with a family with a loved one under guardianship, do not be surprised if the court allows that person under guardianship to have a supporter, and do not be surprised if the court allows that guardianship to actually, or orders that guardianship to terminate. Here is the kicker, I think, and one of the major epiphanies that you may have when you read this. All adults are presumed capable of making a supported decision-making agreement. I'll read that again. All adults are considered capable, presumed capable, of making a supported decision-making agreement, no matter what the level of disability may be. And this is to be construed liberally. It's not just me saying it should be construed liberally. This is what the legislation actually says. Now, if a person creates a supported decision-making agreement, it is not a ground for determining their capacity, their capability. So these are very nuanced but very powerful things when you think about it. A supported decision-making agreement cannot be used as evidence of incapacity, and it cannot restrict an adult from acting independently or assessing their personal information or accessing their personal information. Think about that now in the role of financial advisors, CPAs, and lawyers, okay? A person under guardianship, again, may enter into a supported decision-making agreement. A court may limit or remove guardianship due to the existence of this agreement. A guardian cannot prevent this without, quote, good cause. Now, we're going to talk about that a little bit more, the existing guardian. Support is defined as, so as you're dealing with a supporter, they are allowed and they are mandated to gather information, understand and interpret information, help weigh options for the person. Remember, not making any decisions, but helping them do all these things, understanding the consequences, the pros and cons of a decision. Participating in conversations with third parties. So there we have it. You are at your office or you are at the bank with one of your clients, let's say, and this person is with them, the supporter. They have the right to participate and help converse in the conversation with third parties and providing the adult with the support they need to make decisions. The supporter is supposed to support the will and preferences of the adult without inserting their opinion about reasonableness or the adult's wishes or preferences or choices. Think about that. The supporter is not allowed to say, well, I don't know that that's really a great idea. Now maybe they can counsel, but they are not supposed to insert their opinion. They are supposed to act honestly and diligently in good faith. They are to act within the scope of the supported decision-making agreement, okay? They have to maintain records. Now, many of you I know are worried. What's going to happen here with the records? Well, here it is. They have to maintain records and make them available about their actions as supporters, how they are communicated with the adult, how they communicate and how the adult expresses their opinions, how records are maintained and obtained, and the safety and security of the records. Okay, the relationship is one of trust and confidence. Now, this was one of the main reasons why the legislation took so long, is because of this concern, and it's a valid concern about possible abuse and so forth. And I presented recently at the Brain Injury Association annual conference, and one of the parents that was there expressed that they were very concerned about how this opens up the supporter to liability, and including parents who are supporters. So this is not without risk, but all things I think that we do every day in our lives are not without risk. So this is just going to be a little bit of a wild west kind of situation, I think, for a while. It could take up to 2 or 3 or even 4 or 5 years to see how this is going to shake out as we let people make their own decisions and take risks. A supported decision maker may not make decisions for the adult, exert undue influence on the adult, coerce the adult, obtain information about the adult without the adult's consent, enforce decisions made by the adult outside of their presence unless they are authorized to do so. And of course, we talked about this, they cannot act outside the authority of the supported decision-making agreement. So I would say even more so than powers of attorney and advance directives, this is really a good faith relationship, and it's going to have to shake itself out over the coming months and years. A supporter cannot be a minor, a person who has had a peace order obtained against them, well, thank goodness for that, and a person who has been convicted of financial exploitation, okay? Now, if the supporter resigns, it must be given orally or in writing to the adult and to all the people, the named supporters and third parties who have the agreement on file. Now, I just thought of this as I was talking and just through this slide. I thought about the fact that some of you are asked to be trustees, and you may or may not be allowed to do that in your capacity. Some of you are asked to be trust protectors, and I'm wondering if some of you will be asked to be supporters. So this is something that's going to be, again, a whole new world. The authority of the supporter ends if they are incapacitated or die. Now, the form of the SDM agreement, supported decision making, as we start to wind down, it can be in any form consistent with the statute. More uncertainty. So the statute was passed. It does not show that yet there's going to be an actual form. I predict that there will be a form, or there will be several different forms that can be used that are defined within the statute. I think we at Elville and Associates over the next few months are going to develop our own form, but that form must be documented, dated, and witnessed by 2 adults who are not the supporter or the employee or agent of the supporter. It must name at least 1 supporter and describe the decision-making assistance that the supporter is supposed to provide, okay? And it should describe how the supporters will work together if there's more than 1, and any conflicts of interest that might come up. Now, again, that's very, very much pie in the sky because we don't always know what the conflicts of interest will be ultimately, but if there's anything that's clearly a conflict of interest, we need to set that out. Remember, this does not have to be in writing, but if there is a form, it has to be in a certain form under the statute, and it's just going to be a work in progress. Now, The form or agreement must document how the adult selected the supporter. It must be approved by the court if the person under the disability has a guardian, okay? And the supporting decision-making agreement will affect the authority of the guardian, and it has to be outlined, okay? The court would have to modify its guardianship order and so forth. And it must attain an attestation about the adult's independence in decision-making. The adult can revoke the agreement orally in writing, and can obtain a support from an individual of their own choosing to revoke the agreement. So they can even have support to revoke the agreement, okay? Third parties can rely on the agreement in good faith. I think that's very important for you to understand today, that if someone comes and represents this after October 1st, 2022, or even before, and you rely on that in good faith, I think that you are you're acting reasonably, okay? Third parties can also decline to comply. Now, this is very important on the following grounds. Let's say that you have actual knowledge of the invalidity of the agreement, or you have actual knowledge of a revocation or coercion or undue influence of the supporter. You can refuse. I know that many of you are on the front lines of elder abuse and seeing what children are doing with parents' funds and so forth, or others. And I know that you are very cognizant of protecting your clients and their assets. So you can decline to comply with the supported decision-making agreement if you have actual knowledge that these things are going on. And I think that's something that you will do very well. Third parties can be held liable, however, for causing personal injury as a result of negligent, reckless, or intentional acts, here's a big one, failing to give effect to the adult's decision made in accordance with a valid supporting decision-making agreement. So in other words, if your adult with disabilities makes a decision in accordance with a valid agreement with their supporter, you must give effect to it, or you're risking that you could be held liable. Failing to provide information to the adult, sorry about that typo there, to the adult or supporter of the adult that would be necessary for informed consent. So you're asked for information, and it's necessary to get us from point A to point B with the supporter and their role, and the disabled person and their role of trying to be supported. You cannot fail to do that, and I know this is very ambiguous, and actions otherwise inconsistent with the supported decision-making law. So how can supported decision-making benefit persons with disabilities, young or old, of any particular genre of disability? Persons with disabilities are no longer strictly limited by their diminished capacity. So if you haven't already started to get some epiphany here, or series of epiphanies from this presentation, I want you to let this sink in. People with disabilities are no longer strictly limited. The paradigm of risk encourages the ideal of independence during a road of recovery if someone is injured, or someone has a brain injury, or someone is disabled and is recovering to a certain degree if it's possible. It is a new empowerment and recognition of rights and self-determination. It is articulated legally, and it's new, a new role for supporters, a new legal path. This is a psychological shift. It's going to take some time. It should not be pigeonholed. If you can imagine the scope and the breadth of this legislation, it should not be pigeonholed into one or two things that we allow people with disabilities to do. This is a whole new paradigm, okay? The ideal of independence and the right of self-determination, it is not diminished by the need for guardianship now. Even if guardianship is needed, which in many cases it is needed, it can still have a carve out. It can still allow someone a right or a certain series of rights of independence. And again, new protections from guardianship itself. So that's a lot to cover in the last hour and 20 minutes. You've been very kind to sit through this. What I would suggest is that, number one, we always collaborate together. We love collaborating with you. We want to be a resource to you. We want to help clients plan in the highest and best ways. We at Elvil & Associates believe we're one of the only law firms, if not the only law firm in Maryland, that educates clients, believes in educating them, and actually does that. And so we want to not only educate, but we want to facilitate, as we talked about, for example, the Secure Act and how it's affecting people, not only with the changes in how beneficiaries are treated, but how it's going to be necessary for us to think together from the beginning to the end about how we're going to accomplish the client's goals. If we've done well at the beginning, but in the end we can't facilitate the back-end support that's needed, then the client's plan could fail. And that's one of the things we want to avoid. So we strongly recommend collaboration, whether it's to reduce the tax effects of the Secure Act, whether it's education of clients jointly together, whether it's making sure that we not only understand the recommendations up front for planning and the Secure Act type planning, but also the ramifications of all through the process of administration and how we can run into problems and how do we avoid that given the change of the world that we're living in post COVID-19. We want clients to relax and understand that every meeting is exploratory and consultative and give them time to think. We want to review clients' existing documents. If you would like us to review documents for a client, generally speaking, for routine documents, we do not charge to review them. And I've reviewed thousands of documents and I can do it fairly quickly. If your client does not have a complete advisory team, we want to help them. If you're on this webinar today and you are a potential client or a client of a firm, whether it's financial advisory firm or not, or a law firm, we want to help you facilitate an advisory team if you do not already have one. We want to answer questions that clients have in advance. And again, we want them to become educated. We want the family members to become educated. And we want to give the client and the team time to think together to make the best solutions possible. So I hope today has given you many things to think about. Hopefully you were able to follow me through a lot of that information. I gave you a lot of information in a very short period of time. Please use it. Please ask questions. Let us be a resource to you if you have questions. Be aware of the changes that are coming down the pike with the supported decision-making law and the changes, the paradigm shift that is happening right before our eyes. And also with the Secure Act, be aware that these are the temporary regulations, and all we can try to do is our due diligence from the beginning, middle, and end of the planning process. Jeff, I'm going to turn it back to you, and I thank everyone today for their time and attention, your valuable time spent with us today.
Well, thank you, Steve. A lot of really relevant and important information in that presentation, and thank you very much for going through it for the last hour and 20 minutes. Lots of good information. So we do have a couple of questions here that I'd like to go ahead and pose to you, Steve. And let's start off with the first question here. And the first one's a good one. How might supported decision-making impact any financial support or benefits they may be receiving from state and or the federal government?
Thank you for that wonderful question. I'm going to just say it's not going to affect any benefits. And that's because it is so simple in concept. And it's going to take a while. It took me a long time, as I mentioned, when I first met Megan Bruciano 10 years ago. It will take a while for you to realize that this is very simple at its core. And that is this concept. Persons with disabilities should be able to make their own decisions to whatever extent possible, provided they have the support to do so. That is the whole concept of supported decision making. Persons with disabilities should be able to make their own decisions to whatever extent possible, provided that they have the support to do so. So if you think about that simple concept, you'll realize that it does not affect any of their benefits or anything relating to that, because it is not going to change their status as to whether they are higher functioning disabled people, people under certain disabilities, people with SSI, people with SSDI, people in the Medicaid system. It will not affect any of those statuses.
Thank you. Another question. With verbiage of supported decision-making, will verbiage of supported decision-making need to be included in the conversation of a special needs trust, or is this a separate item?
That's an excellent question. I haven't thought through that issue, but I can imagine that there will come a time, if it's not sooner than later, where there will be, and I would imagine there would be no downside to mentioning in a special needs trust the possibility of and recognition of the fact that the person has a supported decision maker, and that instructing the trustee that they should be cognizant of this. For example, the modern supplemental or special needs trust has many reminders to the trustee, meaning you should be reminded that there are nuances with retirement plan benefits, that there is a memorandum of intent, that there is an advocate, that you can hire professionals. And along the lines of reminding people of what is there for them as far as trustees and how to carry out the trust at a high level, I would imagine that absolutely there would be no harm in mentioning and making sure that the trustee is aware that the person with disabilities, in addition to the trustee's fiduciary responsibility to take care of them, that person may have and does have the right to have a supported decision maker, and that trustee needs to be aware of that and deal with the person accordingly.
Great. And in reference to this next question, I'll say that in the handout section and in the email I sent out yesterday, I did send out supported decision-making agreements for Washington, D.C., Delaware, and Indiana. So those hopefully will be a good reference for you. The next question is, I didn't hear about the supported decision-making conversation in Virginia. What reservations do other states have?
Thank you for that. I have to say, I don't know what Virginia's supported decision-making law status is. We could easily find that out. There are, to my knowledge, about 20 to 22 states now that have supported decision-making laws. Maryland, of course, was latecomer, but the reservation, I'm sure, if I could guess, would be that this is somehow associated with, of course, the paradigm of risk, that there are going to be disastrous results with regard to getting away from the protectionism, that people that are supporters will commit undue influence and fraud and financial abuse and so forth. And I'm sure we will see some of that, unfortunately. But I think the overall risk is outweighed by the tremendous possibilities of self-determination for people. So easy for me to say that we shouldn't worry about it, but I think there will be issues. It's going to have to be worked out over time. Hopefully we will have a just and fair society where people can trust each other in the future, and people can be supported. In the supported type arrangements that I've seen, that prior to the supported decision-making law, in most situations involving people with disabilities, I've seen very, very sincere, dedicated people who are the supporters with no element of abuse. Again, this is limited to my experience. With regard to Virginia and other states, we could easily find out what the status is and where the laws are in that regard.
Okay, thank you. And last question for now, and now would certainly be your time to get any last questions that you have in as we're approaching 11:30. Can the supporter be paid for their services?
That is a great question. I will have to refer back to the legislation. There is, I'm going to go back to my slides real quickly just to see if there's a way that I can address this. There are some limitations on who can be the supporter. And I'm looking very quickly here, who may not be a supporter. I don't see right now, I don't see any prohibition on someone being paid. And I have not heard that that would be a problem. So for example, in the financial power of attorney, where we many times will say that the agent can be paid. I think here we would want to say that the supporter may be paid. I could be overlooking something here, but I don't think so. I don't think there's a prohibition. There was a lot of talk about that, about whether someone who was a paid supporter, paid person, could actually be a supporter. But right now, I don't think that is prohibited. Jeff, I just wanted to go back to the prior question real quick. The person who asked about Virginia, what was happening in Maryland prior to supported decision-making being implemented is that many families felt that they had no choice but to go ahead and create a supported decision-making agreement, even though it wasn't recognized officially by state law. So I'm not recommending that or saying that's the right solution, but families in Virginia, if there is no supported decision-making, could try to be very proactive to create at least an informal situation where you're creating some kind of informal supporter arrangement for a person with disabilities until such time as hopefully Virginia gets supported decision making.
Okay, very good. So it looks like those are all of our questions for now. We are at 11:30, so thank you for being part of our advisors forum as part of our Elville webinar series. Just in 20 seconds here, we do have on Friday estate planning and elder law with Stephen Elville. On June 10th, we will be live at the Howard County Library, the East Columbia branch for estate planning and elder law, again with Stephen Elville. So we're looking forward to that in-person presentation. And then on June 15th, we'll be having Kelly Nelson with Maryland Able, a good friend of ours and the firm, talking about Maryland Able accounts and how they benefit loved ones with disabilities and special needs. All those presentations are at 10 o'clock. So looking forward to those as we go into the summer here at Elville and Associates and the Elville webinar series. So thank you for being part of our advisors forum today. We appreciate your support and look forward to meeting some of you. Please fill out our survey that'll be coming into your inbox in just a few minutes. And we look forward to hosting you again soon. Have a wonderful day, everybody, and a nice Memorial Day weekend ahead.
Thank you.